No part of this lecture material may be used without the express written consent of Rick Ramos or Contra Costa College. This is Professor Rick Ramos, and we are in the Legal Aspects of Evidence course. We're continuing in Lecture 3, Part 2, talking about the kinds of witnesses, and we started off by talking about expert witnesses and lay witnesses and the difference between the two. We're going to start talking about how lay witnesses can give opinions in certain circumstances. So in most situations, there's going to be lay witnesses who are going to be doing the testimony for you in your cases. And you'll find that these people are basically the people who are everyday folks that work on the street. They're going to be your witnesses. So when can they give opinions about certain things? This comes under the opinion evidence rule, which is 800 of the EC, and it allows a lay witness who's a non-expert to give an opinion about what he or she has seen or heard and why they've arrived at that opinion. But the following legal foundation must be fulfilled first. Number one, the testimony is based upon personal knowledge of the witness. Number two, the lay witness's opinion is helpful to clarify testimony and the determination of the facts in the case. And the last or third is the opinion relates to one or more of the areas under opinion evidence rule. Now, the law favors opinion testimony if it will help the trier of fact reach a conclusion on the disputed fact. Cross-examination can bring out weaknesses in witness testimony, and the jury can weigh the veracity or bias of the opinion. Example, the courts have recognized that opinion testimony of a lay witness may be helpful when the matters observed by the witness were too complex or subtle to enable a witness accurately to convey them without resulting in the use of conclusionary descriptions. Ultimately, the responsibility in determining whether or not a person can give the opinion is in the hands of the magistrate. The magistrate may examine a witness beforehand as to his or her ability to render an opinion and has a final decision whether or not that opinion can be given. Common matters involving lay witness opinion: personal appearance, state of emotion, including anger, happiness, excitement, fear, pain, sadness, when relevant to the facts of the case. Some of the author's specific examples are: a stalking victim appeared fearful after repeated threats and harassment by a suspect. A domestic violence victim appeared frightened and upset, or a robbery victim appeared fearful and excited after being threatened with a gun. A deputy sheriff could testify to the personal appearance and demeanor of a shooting victim and the tone and manner of the victim's parting words in order to establish the victim was under an impending sense of death for a dying declaration. A lay witness is permitted to testify to examples of the defendant's paranoid and delusional behavior several weeks prior to a murder in order to establish a claim of imperfect self-defense at the time of the shooting. The other things that can be looked at is demeanor or intent, alcohol or drug intoxication, general physical condition, was a person unkempt, smelly. They can also give opinions about speed and distance. In a vehicular manslaughter case, statements such as, "I thought he wasn't driving with the best control of his vehicle. He passed like a bat out of hell in a crazy place. Passed me as if I were standing still." And speed estimates ranging from 50 to 80 miles an hour were admissible. However, other statements such as, "he's going to kill somebody," and "stupidity caused the wreck" were not covered under the lay opinion rule because these were conclusionary products of personal emotion rather than relevant to the actual observations of the witnesses. Age, identity, and physical description. Opinion testimony related to physical description and stature are the results of physical lineups, infill show-ups, photographic lineups, or voice identification, including the tone, accent, pitch, and individual voice characteristics, are admissible. This area could also include an opinion on the genuineness of handwriting by one familiar with the person's handwritings. Samples. Examples could include: a lay witness may render an opinion of a minor's age in the range of 16 to 20 years. In an unlawful sexual intercourse charge based upon physical maturity and described behavior. Such testimony can help the jurors assess how old a minor looked at the time of the incident, either to add credibility to the state's case or establish a mistake of fact defense. This came out of U.S. versus Yazzie in 1992. In the Henderson case in 95, established that a lay witness could give an opinion on the identification of a bank robbery suspect based upon sufficient contact with the suspect and viewing stature and clothing description, including a hooded sweatshirt, baseball cap, and heavy raincoat. In the Pierce case in 1998, it's permissible for persons having prior familiarity with the defendant, the work supervisor, and a probation officer, to look at the grainy quality surveillance camera photo taken during a bank robbery and render an opinion as to whether or not it was the suspect. So this was a work supervisor and a probation officer that looked at this photo and approved it. In the Beck case in 2005, a probation officer who had met with the defendant on 4 occasions was able to give an opinion that the person depicted in the bank robbery surveillance photo was the defendant. And People versus Lucero in 1998, for the purposes of establishing probable cause to arrest, a police officer was able to render an opinion that the characteristics of the soles of the defendant's shoes appeared to match the characteristics of the patterns left at the counter at a robbery scene for the purposes of arresting the suspect. And in People versus Maglaya in 03, a police officer can express an opinion concerning the similarities between the tread on the defendant's tennis shoes and the impressions left outside a sliding glass door during attempted residential burglary. The last area we'll talk about lay witness opinion is physical characteristics and properties of substances. An officer may give an opinion on physical characteristics and packaging characteristics commonly associated with street narcotics in order to form probable cause to arrest or probable cause to search. Some examples include the Bailey case. Field identification of rock cocaine and cocaine base is permitted by officers, but you should always send the narcotics to the crime lab to have it chemically tested for testimony in court by a witness who would be an expert in that case. Next example is an officer can express an opinion that a suspected bloodstain was located at the crime scene, but the testimony of the expert serologist, which is an expert in blood, is necessary to establish this fact in court. So an officer can use their lay opinion in order to establish probable cause, but needs to have expert witness testimony and examination of the evidence for the actual trial. Officers observing what they believe to be a blood stain on a front door and apparent bruising and swelling on a victim's face were entitled to perform a warrantless exigent entry into the house in order to arrest the suspect. This is People versus Fry, 1998. In the O.J. Simpson murder trial, an officer was permitted to express an opinion about a blood stain found on the door of Simpson's Ford Bronco, in part to justify the warrantless exigent entry into his property in the belief that Simpson or another could be injured. So get out a piece of paper and let's do a little review question here. In a DUI case, a CHP officer could testify to observed symptoms of intoxication and that the suspect appeared to be under the influence of alcohol or drugs under which of the following rules? A. Best evidence rule. B. Intoxication evidence rule. C. Presumptive evidence rule. D. Opinion evidence rule. Or E. Voir dire evidence rule. Stop the tape. Write down the correct answer. The correct answer is D, the opinion evidence rule. The next question I have for you is, can you personally give an opinion about the value of something that was stolen from you? And the chances are, yes, you bought it originally. You would know what it would cost to replace it, and you might have some information on what it would be worth used. So you could give that sort of an opinion. Now let's go back and review expert witnesses and their requirements. An expert witness is qualified to testify either through the voir dire process, which is examining the witness's qualification to testify in court, or if they're stipulated to by agreement between counsel. Usually they have some specific training or knowledge or education that makes them an expert to render an opinion. Areas of expert witness testimony include the medical examiner, who would speak about causes of death, or medical testimony regarding traumatic injury, or a document examiner who would review handwriting, typewriter, audio, or video authentication, or other experts that would testify about fingerprints or ballistics, drug analysis, trace evidence, serology analysis, including blood, semen, saliva, and DNA, skid mark analysis, or psychiatrists who would be asked questions about the mental stability of the defendant. So let's try another study question here. You're an officer and you arrive at a DUI injury traffic accident 7 minutes after it occurred. There are about 300 feet of skid marks created by the suspect's vehicle. Based on this observation, may you testify as a fact in court that the vehicle was speeding? Now think about this. May you offer an opinion that the vehicle was speeding? The answer is probably that you cannot, unless you are qualified to be able to do skid mark analysis. If you don't have skid mark analysis, you're not going to be able to do it. What could you testify to? Well, you could testify to the fact that 300 feet is a long ways, and if you were trained in skid mark analysis, you'd be able to show a formula using the coefficient of friction for that roadway, and the length of the skid marks would equal a certain miles per hour, and match that up as to whether or not it falls under the speed limit in that area, or the safest speed to drive in that area for the conditions. Next study question or review question. Officer Bosco works for Solano County Prison, and she responds to the scene of a suspected knifing between rival gang members. She finds an 8-inch prison-made knife, also known as a shiv, under an inmate's mattress. The blade is stained with red liquid. May Officer Bosco testify in court that the liquid on the knife was blood? What do you think? Is she an expert? Can she test it right there and tell us it's blood? Probably not. But for the purposes of probable cause, can't she testify that it is a red liquid similar in characteristics to blood? That would be what she could testify to. She could testify that it is similar in characteristics to blood, and that she sent it to the lab to be further tested, but she used it as probable cause to establish the arrest. Okay, the last review question for this lecture. True or false? An officer may offer an opinion in the following areas. A tan powdery substance with a positive field test is methamphetamine. Number 2, a domestic violence suspect appeared upset and angry. Number 3, a suspect showed the symptoms of being under the influence of PCP. Number 4, the domestic violence victim sustained a broken nose caused by the suspect. Number 5, gunshot residue was found on the victim's clothing. Number 6, the defendant's voice has similar tone, accent, and pitch as the man who committed the robbery. Number 7, a vehicle was traveling at an estimated 90 miles per hour. Number 8, I saw the suspect from about 35 feet. And the opinion on is that it was 35 feet away. Number 9, the child appeared to have bruises and swelling around her face. And number 10, these devices appear to be gaffs, slashers used for cockfighting. So let's go back over those. Number 1, false. Number 2, true. Number 3, the suspect showed the symptoms of being under the influence of PCP, true. Number 4, domestic violence victim sustained a broken nose caused by the suspect, false. Number 5, gunshot residue was found on the victim's clothing, false. Defendant's voice has similar tone, accent, and pitch to the man who committed the robbery. True. 7. A vehicle is traveling estimated 90 miles per hour. True. I saw the suspect from about 35 feet. True. Child appeared to have bruises and swelling on her face. True. The devices appear to be gaffs and slashes used for cockfighting. True. So all those are true. How about one more? Which of the U.S. constitutional amendments covers the right to subpoena and cross-examination of witnesses? Is it 4th, 5th, 6th, 8th, or 14th? I'm going to let you look that one up. That's the end of the lecture 3, part 2, or the evidence course. Make sure that you're checking your review questions, that you're going online and completing your assignments and keeping up with your student workbook.